Have a Detroit.
Yeah.
Detroit.
What was that? That's all set. All right, welcome to Legislative Committee on Administrative Rules meeting on November 30th, 2023. We'll get started. We'll start by doing introductions, starting to my left.
Anthea Dexter Cooper from the Office of Legislative Counsel.
Chris Bray, representing the Addison Senate District from Bristol, Vermont.
Representative Mark Higley, representing the Orleans Lamoille District.
Senator Mark McDonald, representing Orange County Senate District.
Representative Trevor Squirrel, representing Underhill and Jericho. And on Zoom, we have
Representative Carol Odie, representing the far north end of Burlington.
And Representative Seth Bongartz, representing Arlington, Manchester, Sandgate, and part of Sunderland.
and our supporting staff.
Committee Assistant Lindsay Fryer, Legislative Operations.
Okay, welcome. And Senator Weeks is traveling. Apparently he's in Pakistan. And Senator Lyons is another meeting. We have lots of meetings going on this time of the year. So we do have a quorum with the two folks on Zoom and the four of us in the room here. And we'll start with the minutes. November 16th, 2023.
I'll move the minutes.
Representative Odie has moved that we approve the minutes of November 16th. Any discussion? Hearing none, all those in favor, please say aye. Aye. Opposed? Okay, thank you. All right, first up, we have Rule 23B32, Office of Child Support Guidelines. Kyle Hatt, staff attorney, and Jessica Seaman are the two folks I have on the list here. Sorry, I can't read all the names on the Zoom screen. One of my glasses on.
He's actually here.
Sorry?
He's here in person.
Okay, he's here.
Hello.
And Jessica's on Zoom. Okay.
Good morning.
Morning.
Morning, Kyle.
Morning.
You're the one speaking, I assume.
Yes.
Please proceed.
The committee has before it the quadrennial updating of the Vermont Child Support Guidelines. As the committee surely knows, child support in Vermont is determined in court pursuant in the first instance to child support guidelines, which incorporate various and sundry calculations and considerations, the primary ones of which are parties' income, requiring a conversion from gross monthly income to post-tax income, and a consideration of the monthly household expenditures on children for families who are presumed to be intact of certain means. Those considerations, income and monthly household expenditures, are addressed in tables which are attached at length to our proposal, in which at least quadrennially are required to be updated by federal regulation. And in discharge of that duty, as well as state law, we are proposing to do so to this committee today.
That's it?
Yes, happy to answer any questions.
Committee members, any questions? Not seeing any. I'll entertain a motion.
We have another witness here.
She's just joining them. Senator McDonald has moved approval of 23B32. Any additional discussion? All those in favor, please say aye.
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 Opposed? Thank you. That's quick.
Thank you very much.
Thank you.
Have a nice day now.
Okay, next we have, at least in this order right now, we have 23 P18 Vermont Public Utility Commission, Rule 5.400, petition to construct electric and gas facilities pursuant to 30 VSA 248. And we have John Carter with the Public Utility Commission. Before we get started here, yeah, please be seated. I think our approach to the rulemaking, and I'll have an additional question before we get started about 5.5 and 5.4, but our legislative counsel, who's the content expert on this, hasn't been able to provide some answers to questions that members of this committee have regarding statutory authority and things like that, okay? And so most members are still trying to wrap their heads around the issues that are being discussed here, the proposal from the PUC and the arguments against some of those provisions from other organizations and folks. So we're going to listen to the testimony today from yourself, PUC, and the other folks that are here, and ask our questions and go through that process. And then we will also and then schedule for the next meeting to have the additional conversation with all the information, so that I feel that all the committee members are in a place where they have enough information to make a good decision regarding this one, just so we all understand that. My next question is 5.5 and 5.4, are they connected to each other, or can 5.5 be taken up separately and voted on, or are they tied together?
No, I believe they can be done separately. 5.5 is really about what happens when you actually plug something into the electric grid. Can it be done safely and so forth? So
we can take that up. We might be able to move that along. So
yes.
Okay.
Jamie Aaron will be over here shortly to handle that particular role.
All right. So let's take up 5.4, and the floor is yours.
Okay. Thank you very much. Good morning. My name is John Cotter. I'm a staff attorney and deputy general counsel of the Public Utility Commission, and I'm here this morning to present the Commission's proposed amendments to Rule 5.400, which is a rule that governs the process for seeking review of projects subject to 30 VSA Section 248. After hearing the comments from the chair about needing a little bit more time to examine the questions of legal authority, that actually sort of dovetails nicely with what I wanted to do today anyway, which was to respectfully refer the committee members to our written response to the comments, where we do go into detail about why we believe the commission does have the legal authority for these particular amendments. And largely it's because we believe they're procedural in nature, not substantive, and that there is statutory authority for the commission to have procedural rules in place. So what I'd really like to do is talk more in broad brush strokes about the policy matters here. The rule actually, the amendments do four primary things. One is increasing the clarity on the information that must be filed with the 248 petition. The second is it updates the means by which parties can collect and exchange information, as we've learned a lot, obviously, with technology advancing and then our COVID experience. They third provide further clarity on the processes that must be followed to amend a certificate of public good. And those three things don't seem to have engendered any controversy. It's the fourth goal of the, which is to simplify the process for certain persons and entities to participate in Section 248 cases that seem to be the source of controversy. So what I'd like to do is talk about the Commission's goals behind that and what we hope to achieve and what we think the unfortunate result would be if this committee adopted the recommendations of the folks that are opposed to those, and understanding that everybody, reasonable minds can disagree on these things. The amendments in question that seem to have engendered controversy are The first is an increase in the number of persons who are entitled to receive an advance notice that a developer or a utility will be filing a Section 248 petition. The second one is an increase in the number of persons that are entitled to receive notice that the petition has actually been filed. The third one is an increase in the number of persons who can obtain party status in Section 248 cases by filing a notice of intervention as opposed to having to go through the process of filing a formal motion to intervene. The Commission's goals in all of these are consistent with direction that we received from the legislature in 2016 when Act 174 was put in place, which directed the Commission to make all Commission proceedings more accessible and user-friendly to citizens. And that grew out of, I believe, hearing the frustration from citizens in trying to understand and participate effectively in Commission proceedings. And at least in some measure, that was related to Section 248 proceedings. So let's talk about the three topic areas. So the first one, I think it's important to note that the people that have filed comments in opposition to these changes, their objections are focused on adjoining landowners and on the Natural Resources Board. So let's talk about the first one, which is advanced notification. And this is just simply a notice to people that in the future, we are going to file a petition for a project, and the people that we think should be entitled to notice of this include adjoining landowners and the Natural Resources Board. It's our experience that the Natural Resources Board and adjoining landowners tend to have interests in these projects. So we think that having notice before a petition is filed allows for engagement before the petition is filed, before litigation actually starts. People can go to the developer, they can go to the utility and talk about any concerns they may have. And sometimes it may be that their concerns were, I shouldn't say non-existent, but they didn't understand the project well enough. Other times, maybe they can talk to them and ask for a little more screening, perhaps, between their home and the project. So we don't think that increasingly, or I should say adding adjoining landowners in the Natural Resources Board to the people that are entitled to know that a petition will be filed is going to increase litigation or increase costs. We actually view it as an opportunity to avoid litigation and possibly decrease costs. The second point is who is entitled to notice that the petition has been filed. And again, Natural Resources Board, excuse me, I should go back for a moment. The actual costs of providing the advance notice are not going to be material in the context of an overall 248 petition and project. We're talking projects that range anywhere from hundreds of thousands to millions of dollars. You're talking about the increased costs of copying materials and mailing them to people. Now, obviously, the larger the project, the more people there will be. But again, the larger the project, like a large transmission line project, you're talking about a much larger cost project again. So I think it's important to keep the costs in context. So then, and we also have made it easier for people to identify adjoining landowners. We've also opened up the possibility of electronic service versus paper service. So we understand the concerns and we're trying to address them. The second point is notice that the petition has actually been filed. And we think that this is important because we all refer to it as 45-day notice, the advance notice, because you have to give that to people at least 45 days before you file the petition. But once you've issued that notice, you have up to a year to file your petition before you need to restart the process. And so time goes by, people don't hear anything after the 45-day notice. They're wondering if this petition is actually going to get filed. Boy, they thought it was going to be around 45 days afterwards. So we want people to know that, yes, the petition has actually been filed and the project is moving forward. I wanted to mention two things about the opposition comments here. One is they rely on a section, a particular subsection of Section 248 that dictates who is to receive service of the petition and all of the supporting materials. And they say that the commission cannot go beyond that, that section, prohibits the commission from requiring notice that the petition has been filed. But that subsection doesn't talk about notice. It talks about service of the entire petition. So even if they're correct that it has some preclusive effect, it doesn't have any effect on notice. That's point one. Point two is if you take their comments in entirety, what they're asking you to do, and they're asking you to direct the commission to not only, we're asking you to not only vote against these amendments, they're asking you to direct the commission to change something in the existing rule. In the existing rule, adjoining landowners are entitled to notice that a petition has been filed. So that's not even part of the amendments here today. But if you go in the direction that they're suggesting, an adjoining landowner and the Natural Resources Board will not receive advance notice that a project is planned and a petition will be filed. They will not receive notice that the petition has been filed. These folks could potentially know nothing about a project until it's been approved and a bulldozer shows up on the neighboring piece of property. And we don't think that's appropriate, and we don't think it's consistent with the dictates of Act 174. The last point is the intervention by notice. And we have two issues with the commenters' positions. Basically, they're concerned that it's going to cause a greater number of people to intervene in the cases, and the cases will get more complicated and more expensive. And I will sit here and acknowledge absolutely the more parties you have in a case, the more complicated it is and the more expensive it will be to get to the end of that case. But the commission doesn't believe that offering adjoining landowners in particular and the Natural Resources Board an opportunity to intervene by filing a notice of intervention as opposed to a motion will result in more people intervening. This is because participating in a Section 248 case, particularly a large controversial one, is a significant commitment of time and resources. So we don't believe that the decision to intervene is being made on whether somebody needs to go through the step of filing a formal motion as opposed to filing a form that notice of intervention is what drives those decisions. These decisions are driven by people who have real concerns and are ready to commit to the entire process. So we just don't think that that's going to cause the problems that the other commenters believe that it will cause, excuse me. So I think I would like to just leave it at that, and I'd be happy to take any questions. I know that there are some other folks here that need some time before the committee today.
Thank you. Senator Bray.
Are there legal consequences to beyond notice to expanding the scope of those who are automatically parties? For instance, would individuals who would otherwise not been able to, they appeal the permit or challenge the permit in some way that under current law they would not be?
Well, if the person intended, and again, let's keep our eye on the prize here. What we're really talking about is adjoining landowners. And when an adjoining landowner historically has come before the commission in a Section 248 case and said, we want to intervene, here's our concerns. And if those are legitimate concerns, the commission does not deny intervention. They get party status. They just have to go through a more formalized process. And what we're hoping these amendments will do is that when somebody shows up with those legitimate concerns, they don't have to go through as formal a process. They file a notice of intervention. Now, the commenters have suggested that, excuse me, I should go back to directly answer your question. So no, there's no difference once you're a party. If you're a party, you have a right to appeal the outcome of the proceeding. But the commenters suggest that the notice of intervention process will result in people intervening and raising issues that have no relevance to Section 248. They've asserted that the motion process allows them to understand the concerns that the intervener has so they can start a dialogue with them, which, by the way, that dialogue could start much earlier if the 45-day advance notice was given to them, but they're opposed to that as well. But the fact is that the notice of intervention process in the proposed amendments requires the person to list issues of concern to them and to explain how they're affected by a decision in a 248 case. So it's not opening the door for the Wild West and people to raise whatever issues that they want. It still has to be relevant to the Section 248 case.
And does it have any impact on what grounds someone can raise an objection to? Does it change the scope of the bases that an adjoiner could raise concerns about a project?
I want to be sure I'm answering your question correctly. When you say an objection, you mean an objection to the project?
Yeah. I mean, are there criteria that they will, someone could potentially object using that they wouldn't otherwise be able to use if I chose the changes proposed?
Sure. I want to make sure that the broader question, I'm going to start by answering it more broadly to make sure that I'm covering everything that you're asking. It will not allow people to raise issues that are not contemplated by Section 248. Okay. Will they be able to raise issues within Section 248 that they would not have been able to raise before? Is that your question? Well, the way the proposed amendment is written is that they have to identify their issues. The intervention by notice is still subject to the commission's authority to limit somebody's intervention. So that if the person, for example, wanted to put on testimony on something that required expertise, but they did not have the expertise, then I believe that the commission would use its discretion to limit that person from not participating on that issue. That said, they could put on a witness that had expertise. Substantively, I don't think the end result will differ significantly from the end result that exists right now. I think that the comments are respectfully a bit hyperbolic in that regard.
The other thing, I don't know these projects, I don't know how many there are in a year, but do you have any concerns around the 45, not being able to get waivers on the 45-day window, ever slowing down a project that has some urgency to it? Or I'm trying to remember the number. There's a 248 J that's for emergency work, but are there other projects that don't rise to the level of sort of urgent or emergent work, but you're still going to have some loss of timeliness for processing and permissions and then construction?
Yes, I think just to clarify, 248J is a slightly simplified process for 248 generally. It's, I think, K, I believe, is our transformer is about to blow up tomorrow. Can we please replace it today?
It was on the right line.
And 45-day notice has nothing to do with those. I personally don't think so. I mean, I put this in the comments. I did some research. Vermont Electric Co-op was the primary commenter. And so I did some research into their history, and I went back 5 years in our electronic filing system. And I found that they were involved in a total of 5 248 cases, 2 of which I believe were filed under J, which still requires 45-day notice. And in only one of those cases in 5 years was the waiver actually utilized. And that was the case where VEC wasn't even the primary petitioner. They were sort of a minor player. They happened to be a co-owner of a couple of poles that were going to be moved as part of a larger project. So the vast majority of cases don't rely on 45-day waivers. So even accepting that, yes, more people will need to be contacted and more waivers will need to be requested if somebody wants to request them. The 45-day waiver provision is generally, if not exclusively, only used for simpler, smaller projects. People are not waiving 45-day notification for large projects. It's just simply not the case. So the worst case scenario would be somebody needs to wait 45 days before filing their petition.
Good. Representative Bongartz or Representative Odie, any questions? Hearing none. Thank you.
Okay, thank you, and I'll look forward to coming back again.
Oh, I'm sorry, Senator McDonald. Let me.
I'm trying to get my head around the changes that the PUC is proposing.
Yes, sir.
And my understanding is the law has set forth those people who are entitled to participate, join, and be notified. Is that correct?
The Section 248 identifies certain people that are entitled to appear by right. It also identifies 3 entities, that would be the local and regional planning commissions and the local select board, I believe, that are entitled to the 45-day notice. Yes, that is true. And the changes that the commission is proposing would increase the number of people who are entitled to the 45-day notice. I would not characterize the increase in the amount of people who can intervene by notice as an intervention of right. It is a change in the process by which they intervene. So I understand the objections that the commenters have made to the expanding those lists of people. I, however, just respectfully disagree with them that the existence of certain people or entities identified in the statute creates an exhaustive and exclusive list that the commission cannot expand upon, because the commission has been granted express statutory authority to adopt procedural rules. And what these changes are changes in the process for seeking 248 review. It's not a change in the substance of the 248 review itself.
So people that might have been interested in participating, who have been banned from participating by statute, would now be permitted to participate?
But respectfully, Senator, nobody is banned by statute from participating.
Then what's broken about the current law or the current rules?
Well, I'm not suggesting there's anything broken about the current law, the statute. We believe that the rule can be improved. We believe that that an adjoining landowner to a project should know that that project is going to be proposed and that a petition for approval of that project has been filed. This is somebody who potentially is going to be impacted by that project. So we think that this is appropriate. We think it's consistent with legislative intent as represented not only in Act 174 that was passed in 2016, which directed the Public Utility Commission to increase access to its proceedings. We believe it's also consistent with the language of Section 248. The ultimate finding that must be made under Section 248 is that a project is in the public good. And so providing information to the public earlier in the process, we think is consistent with that, and we think might help resolve controversies before they get to the litigation stage.
I don't disagree with the notion that this may be a good idea. But we don't change policies. The legislature does, and why is this new idea which changes the threshold or the gatekeeping or the notification of the above? Well, why is it isn't, we don't usually weigh in on such policy decisions. Why has this not been taken to the Committee of Jurisdiction, which may very likely concur with the wisdom that you have had today?
No, I understand your point, and I respect it very much so. But my suggestion here is that what the commission is proposing is consistent with the policy directives of the legislature. I mean, this is often what rulemaking is about. The legislature grants authority to an administrative body subject to a policy direction, and then we have rules that implement that policy. As I said before, Act 174 said, open these proceedings up to people, make them easier, make them more accessible. This is consistent with that directive. We're simply exercising our rulemaking authority, which we have been given under several statutes, to adopt procedural rules to implement the very policy that the legislature has placed before us.
Mr. Chair, I'm worried when the PUC or anyone else questions that suggests that the law falls short in certain areas of being as efficient as it might be, and then deciding themselves to change policy instead of taking their wisdom and their interest to the committees of jurisdiction whose job it is to examine and offer changes in policy. That's not our job.
No, I understand. I don't disagree with you that it's not the job of the Public Utility Commission to change state policy through a rulemaking. Where I think you and I are parting ways, respectfully, is that I believe we're implementing policy that has already been put in place by the legislature. And I understand that we could end up disagreeing on that. I truly do, but that's my view on the issue.
Mr. Chair, I feel I've been burned before as a committee of jurisdiction to find when the PUC has changed the policy and the way things work. And we go, how did that happen? The statute says, how did this happen? And whether it's happening for good or for detrimental reasons, it's not your job to make certain changes. Your job is to make changes that conform with statute rather than change procedures for what you think are proper policy, but haven't been delegated. So I'm eager to hear any other questioning that might take place. I say to myself, we're back again with the PUC making policy that they haven't been directed to make.
Well, Senator McDonald, if I may, I appreciate your comments and I will take them back to the commissioners for their consideration.
I have a quick question. You reference Act 174, 2016. And since that act passed in 2016, these particular rules that are in front of us, or these modifications to these particular pieces of the rule, when was the last time they were changed?
Those particular pieces, not since 2016. The commission.
So my question would be is if there's such a need to make a change and the legislature, according to you, gave you permission to go ahead, why 7 years later?
Well, I think it's part of a process that's been ongoing since then. Since that act was passed, a working group was formed to take input from citizens and other stakeholders, and changes were made. Actually, I should backtrack. I believe that changes were made to this rule in response to that with respect to wind projects by creating what's known as the 10-mile towns and increasing notification to those entities. But there were also a number of other steps that the commission has taken. For example, we've drafted and published numerous guides on how to participate in commission proceedings generally and how to participate in very specific sorts of commission proceedings. There's very extensive material that we posted on the website. And as time goes by, you get more and more feedback from people. Another example was, I think it was about a year ago when we were before this committee with significant amendments to Rule 2, which is our basic rule of procedure. So this has just been, it's been part of an ongoing process. And when people raise issues, we take them under consideration. And, perhaps we should have done this earlier, but we are where we are. And as I said, it's been part of an ongoing process with a lot of effort by the commission to try to make our processes more transparent.
Other questions? Thank you.
Thank you very much. Have a nice day.
Next up is Jonathan Dowds, Deputy Director of Renewable Energy Vermont.
Good morning, and thanks for the opportunity to testify today. As I said, my name is Jonathan Dowds, and I'm the Deputy Director at Renewable Energy Vermont. REV objects to several of the proposed changes in Rule 5.400 on the grounds that they exceed the PUC's authority and also contravene the legislative intent behind Section 248. As Mr. Cotter summarized, specifically, we believe that three provisions, the advance notice provision, the notice of a completed CPG petition, and the process of granting automatic party status have been expanded in ways that are inconsistent with legislative intent and with the PUC's authority. In all three of these instances, Section 248 provides a clear and definitive enumeration of the entities that the legislature identified as requiring notice or being eligible for automatic party status. So this is not a matter of the PUC filling in gray areas. Instead, it is a matter of altering statute that is in fact very explicit. These changes, we feel, also amount to substantive changes in the process. Specifically, the right of a petitioner to object to a motion to intervene disappears when petitioners can instead gain party status by filing a notice of intervention. These changes also undermine the intent behind Section 248, which appropriately recognizes that these types of infrastructure projects require a systemic state-level viewpoint and must be evaluated on the public good rather than purely local or private interests. In fact, the Vermont Supreme Court has stated that this court considers it settled law that proceedings under 30 VSA Section 248 relate only to the issue of public good and not to the interests of private landowners who are or may be involved. And that was Vermont Electric Power Company versus Bendel back in 1977. So this is a long held understanding here. We feel that the current process that allows the Public Utility Commission to vet motions to intervene ensures that the applications have merit and that the applicants warrant party status. Mr. Cotter alluded to this when he said most of these motions to intervene are granted when they have a legitimate reason for doing so. It is that gatekeeping right there, that assurance that an individual does have a legitimate reason for intervening, that we are very concerned is lost under this rule, under this proposed rule. If this is lost, I heard Mr. Cotter say that he believes that our concerns here are hyperbolic. Respectfully, I believe that the PUC's position that eliminating these thresholds won't lead to more interventions and longer and costlier cases is naive, especially in a national environment where we have right now, where there is as much misinformation about renewable energy projects. Some of it funded by dark money and fossil fuel groups. In that kind of environment, the notion that individuals would not take advantage of a lower threshold to intervene, I'm just incredibly skeptical of that assertion. Mr. Cotter rightly stated that individuals who do have a legitimate case are granted party status. And historically, this has been, I think, the majority of applicants. But I believe that vetting process also serves as a deterrent for people who do not have what the PUC would deem legitimate concerns from entering that intervention process. So what we are asking the PUC to do is to maintain its historical role to vet and ensure the legitimacy of the objections of people who are looking to intervene in cases, rather than opening it up to what I am, in fact, concerned is a Wild West scenario where anyone who does not like a project, regardless of whether or not it conforms with Section 248 criteria, will seek to use the intervention process as a way to delay, stall, and ultimately kill projects that are in fact in the public interest. I want to cite two things that the PUC has said about these changes. The first is from July of last year, when they said, based on the Commission's experience, newly identified persons and entities have in certain cases, the newly identified persons and entities, that being the people who are being given the 45-day advance notice and the right to party status through a intervention notice, have in certain cases adequately expressed some direct income in the outcome of Section 248 proceedings. What that does not say is that all such entities who have attempted to gain party status have expressed direct interest, adequately expressed a direct interest in these cases. So the PUC's gatekeeping happens now. It is effective. As Mr. Cotter has stated, individuals who have a legitimate case under the 248 criteria are given party status, and those who are not are excluded from that process. The other point that I want to raise, and this is also from the PUC's filing, in this case, it is on the form submitted to this committee at the beginning of the month. The PUC cites an increase in public interest in those Section 248 cases as a reason to make this change. In our view, the increase in interest in Section 248 cases is in fact the very reason to keep this gatekeeping function. The legislature explicitly stated who must be involved in these cases. The PUC has set up a process that has been in place for many years now and has worked effectively at determining where permissive intervention is appropriate. As we have more interest in these cases, it becomes more important rather than less important that the PUC act in this gatekeeping way and ensure that people who gain party status have this legitimate interest. Because we believe that they have understated how this will impact the number of people and entities seeking to intervene, we also believe that their economic impact assessment is inaccurate, and we are concerned that it is significantly understated because, as Mr. Cotter has said, the larger the number of interveners, the more expensive and the longer a case is. For all of these reasons, we believe that these changes would make Section 248 permitting longer, less certain, more expensive, and less effective at advancing the public good. That concludes my comments for today. Again, I thank you for your time, and I'll be happy to answer any questions that the committee has.
Senator Bray.
Thank you. I guess I'm trying to distinguish between two things that we're talking about and wonder what your thoughts are on each facet. One is, do you have any concerns about automatic, expanding the number of people who are given notice of a project?
Rev members are not heavily impacted by that change. I think the same logic that says that where the legislature has spelled out a specific set of entities that are entitled to something, that the PUC legally needs to respect that. So we do not believe that the PUC has the authority in this setting to make those changes. If they went to the committees of jurisdiction, that would likely not be a topic that Revs weigh in on, because as I said, Rev members rarely, never to my knowledge, take advantage of the opportunity to have that waived. We see the value of that to the utilities, and we believe that in all three of these expansions, the PUC is exceeding its power in expanding those entities, but we would not likely oppose a legislative change that expanded who was able to receive a 45-day advance notice.
Thank you. So yeah, the other half of the question that is really not relevant, which is if you're objecting to the fact that this interpretation has happened, then again, it covers everything. To Senator McDonald's point, I can imagine a conversation in a committee of jurisdiction about expanding notice, but not expanding automatic party status, allowing the gatekeeping function to continue, but trying to make it easier for people to be aware, you know. And unfortunately, we're not in that situation in this room because of the way the rule has been approached.
Yeah, we would certainly be interested in being part of that conversation if that arose through the legislative process.
Thank you.
Thank you.
Okay. Yes, we are. Jake Clark, Vice President of Development, Encore Renewable Energy.
Good morning. Thank you for providing some time for me to speak with you. My name is Jake Clark. I'm a member of the development team with Encore Renewable Energy. We're a solar developer based in Burlington, Vermont. Been active in Vermont for about 15 years. There's around 30 to 35 people in the company, and 22 of them are based here in Vermont. As Mr. Cotter said, reasonable minds can disagree on the subject matter that we're discussing today. I think I'm one of those reasonable minds. So I'll jump in. The core of the matter that I'd like to discuss is the new proposed rule 5.409 addressing intervention by certain persons and entities. But before I get to that, I think I'd like to talk briefly about Senator Bray's last couple of questions for Mr. Doubts. I should say also that I'm speaking on behalf of Encore and on behalf of Renewable Energy Vermont. Encore's a member. On the advance notice, I do agree that sort of the universe of people and property owners and entities who are entitled to advance notice should be as broad as possible. In every single project, Encore has built its reputation on working with landowners, neighbors, communities, towns to identify, address, resolve any concerns that may arise. So we actually send out a notice to anyone who we perceive who may have an impact from a project before the petition is filed. And we do that as an operating protocol. Part of the problem here is that on a recent project that comes to mind, there were, it's a large parcel. There were 55 adjoining landowners. Only 5 of those adjoining landowners could even see the solar project. If you want to give all adjoining landowners the right to intervene without any bar, without any gatekeeping function, you're talking about 50 adjoining landowners who cannot even see the project from their property. That's sort of at the core of the issue. So we're the Renewable Energy Vermont and Encore, we're on board, we're supportive of distributing advance notices to everyone who may potentially be impacted. And all adjoining landowners, the town, the regional planning commission, everyone's going to get those advance notices, and that's fine. You know, it does come at a cost. We have to send these things out by certified mail. I've gone to the post office with a box of 60 advance notices. Each of them is about 20 pages long. And the folks at the post office say, all right, we'll do 10 at a time. So you'll do 10 and then you go to the back of the line and go again. So there is an administrative burden here, but that's beside the point. On to the intervention component. The existing rules, this is rule 2.209C, like full disclosure, I worked as a staff attorney for the Department of Public Service before I went to work for a solar development company. So I have seen this from both sides. I've seen it from the regulatory side and I've seen it from the development side. And I hope that provide some context for, my comments here this morning. The existing rules state that an applicant will be granted permissive intervention when the applicant claims an interest in the matters that must be resolved in the proceeding, and the applicant is so situated that the disposition of the proceeding may, as a practical matter, impair or impede the applicant's ability to protect that interest, unless the applicant's interest is adequately represented by other existing parties. So really what this permissive intervention, what the existing bar says is you have to articulate something that's above and beyond the public interest at large. Your property, your land, your interests cannot be adequately represented by other parties in the proceedings, then you're in. Renewable Energy Vermont's position and Encore's position is that that existing bar is sufficient. What the Public Utility Commission is proposing is to say, if you're an adjoining landowner, there is no bar, you're in. No assessment of the legitimacy or validity of the claims, of the claimed interests, which are being expressed by these adjoining landowners. So it's our position that the existing rules are sufficient. And this brings me to my second point, which is that the legislature intentionally vested authority over projects which benefit the state at large. The Section 248 proceeding is called a Certificate of Public Good, a CPG, but public good. These are projects which benefit the state at large, not individuals. They benefit all of us here in Vermont. If the state of Vermont has enacted a number of statutes now, but like big picture, 90% renewable by 2050, right? If we're going to hit 90% by 2050, we need more renewable energy in state. If we're going to get there, we have to recognize that these are projects which benefit the state at large. And this is why the legislature intentionally vested the authority to issue permits for these types of projects in a state level entity, not in the local authority. They said, let the state make decisions about these projects that will benefit the state at large. What this proposed change to intervention in these Public Utility Commission cases does is it transfers more power back to the locality, in my view, in direct contravention of what the legislature intended when it vested this type of authority in a state level entity. So, any time that you give this type of power to any adjoining landowner without any regard to the validity or legitimacy of the concerns that they're expressing, you're taking that state authority and you're bringing it back down to the local level, which, in my view, is only going to be detrimental to the advancement of Vermont's renewable energy goals. I think I'll just restate that the existing rules provide for intervention. The only thing a landowner or anyone in the public has to do is say, this is my interest and this is what I'm seeking to protect. And the PUC has a gatekeeper role, as Mr. Dowds and Mr. Cotter have said, to say, all right, that you should come in or maybe not. And in our view, what this rule does is it abandons that gatekeeping role in its entirety. So I'll pause there and I'll thank you for your time.
Senator Bray.
Thank you. So it's the PUC that adjudicates whether or not an interest expressed by a particular landowner has merit?
That's correct.
Okay. Do the applicants participate sort of proactively to argue if they don't think that argument has merit? I mean, are you put in the...
An applicant could, Senator Bray, but I've never seen that happen. An applicant, whether it's a Vermont utility, whether it's an electric utility or a gas utility, or an applicant, a private developer for a solar project, the natural reaction is to say, let's resolve the concern. I don't want to say, I object to this intervener. I would say, let's work to resolve what's at the core of the issue here.
So if it doesn't necessarily trigger, if more people were to intervene, does it increase the burden on the applicant? I know you have more notices to send.
That's fine.
Multiple trips through the line. Does it increase the legal burden on the applicant or costs because you wish to see someone excluded, and so basically you're not relying exclusively on the gatekeeper function and the adjudication by the PUC itself?
So any intervener has the ability to, it's a privilege and it's a burden. An intervener can serve discovery, they can introduce their own witnesses, they can introduce their own testimony, and then the applicant or any other party in the proceeding could serve discovery on the intervener, and the intervener would have an obligation to respond to such discovery. There is definitely a burden. And in any case where there is an intervener who's opposed to the project, that will, without any uncertainty, that will prolong the proceeding. The Vermont State Auditor released a report on Monday, I believe. If maybe it was yesterday, I think it was Monday, on the Public Utility Commission. And this is Appendix 3 of the Vermont State Auditor's report on the PUC for citing cases under Section 248. In 2021, 236 days. In 2022, 207 days. I actually find these numbers to be surprising because my experience is that it's more like 300 days or 320 days. But anytime there's an intervener, the duration of the proceeding is going to be prolonged. And for every proceeding where the duration of the CPG process is extended, we're talking about just more and more money lost. Sure. And in my experience, when there are interveners, we'll do everything that we can to address their concerns. If there are interveners who persist, the issue is not that there is some item that we can correct for. The issue is that they have a opposition to solar that cannot be overcome. And then with that sort of innate opposition, they have the ability to prolong the proceeding and create delays without the PUC having any ability to step in and say, well, this is not something that can be recovered or something that can be corrected for.
And then sort of the same questions I was asked Mr. Dowd was the two different things that we're talking about. There's a notice provision and then there's party status. Do you differentiate between the two? I mean, like, for instance, it sounds like your practice is that notice is something that you sort of go above and beyond the law to provide already. It's a question of then someone getting automatic party status. It's a troubling proposal.
Right. The notice, we're fully supportive of any desire to expand the notice provision. There's, as I said, it comes with an administrative burden, but it's a good practice. We need and we want for everyone in the community to know about a project in advance of the petition being filed. so that we can address any concerns that might come up before the petition is filed. And on the intervention side, yes, we do see this as a very, very serious risk to Vermont's ability to achieve its statutory goals of 90% by 2050.
I may just one last question. So if the gatekeeper function is kept in place, does that protect applicants from having to respond to motions for discovery, et cetera, et cetera, et cetera? So that
the gatekeeper function allows petitioners to, or allows the PUC to decide which applicants for intervention have a legitimate reason and which might not have a legitimate reason. And once they're in, the PUC can say, all right, you are an intervener, and the PUC can stipulate, these are the interests that you expressed. You said you were concerned about stormwater, and you were concerned about the visibility of the project. We'll let you in, and you can introduce testimony on those criteria under the Section 248 statute. You shouldn't be talking about things like deer wintering areas, because you said you were concerned about stormwater and aesthetics. And the PUC can say your intervention is limited to these specific criteria. And that is the appropriate role of the PUC as the gatekeeper in this sort of state level decisional authority over projects that benefit the public good.
So in part, it's that there's sort of an unbounded ability to intervene if you have automatic party status.
Exactly. It's the PUC's request for a change that says we don't have an obligation to assess the validity or the legitimacy of the concern being expressed. If you're an adjoining landowner, then you're in.
Representative Bongartz.
Thank you, Mr. Chair. I'm curious from the witness, you've made mostly policy arguments, and I understand that and understand why you feel compelled to make them. But, this is, on the one hand, this isn't a policy committee. And so the issue for us is limited to whether the board has the authority to make the change or whether it's arbitrary. And it would be helpful if you would comment on those, on that part of what is actually within our charge. I don't mean to make that sound critical, because I understand why you said everything you said and why you made the policy argument, but I do want you to take, since you're here, to really to zero in on the parts that we really have the decision-making authority to consider.
With respect, I view that as a question for legal counsel, and I am not qualified to comment on the sort of the divide here between policy and the legal authority of this committee.
Okay, that's fine. I understand. That's okay.
I would say, in my personal view, that this is an example of jurisdictional creep on the behalf of the PUC, which will threaten the viability of continued renewable energy development across Vermont.
I would just put that question out there for next witnesses as they come, whoever feels qualified to comment. So thank you.
All right. Well, thank you all for your time. I genuinely appreciate the opportunity to speak with you this morning.
All right. Thank you very much. Next up is Jacob Flanagan.
Hi there. Thank you.
Just 1 second. I'm sorry.
Sorry about that.
I noticed that Ledge Counsel is in the room. Ellen, and I will never try to pronounce your last name because I'll always butcher it. But I'm not asking you to respond. I made mention before you came into the room that we're looking for something from you to help us understand some of the issues that we need to address as the committee, legislative committee on administrative rules, not as a policy committee. And we look forward to getting that information. Thank you. Proceed. Thank you, Jacob.
Thanks. And I'm Jacob Flanagan. I'm a resident of Vermont, and this is my first time testifying, so sorry for my fumbling in advance. Why I'm interested in this, so I've been engineer in the solar industry for a while now, since 2009. I've been a role in a lot of the projects across the state. I'm no longer, now I'm working on projects that are outside the state, but I still care about Vermont and doing at least its part to address the climate crisis. So when I heard about these proposed rule changes and kind of understood what their effect would be, I thought I should speak up. And in particular, I'm concerned about the change in intervener status that we've been discussing so much. We in Vermont have kind of what I'd call a building or a change or a development aversion problem. And I think it's becoming very acute and noticeable for our housing stock. We're kind of in a housing crisis because we haven't been building enough. And I think we're kind of on track with our electrical infrastructure as well. We know we are going to be electrifying, and we know we're going to have a lot more projects to build on our grid. So why I say that is because there's a lot of things that the state has done right. And that a couple examples are our simplified net metering registration process and our statewide tax on solar process. And that's because they're statewide processes. You know, it doesn't change based on the jurisdiction. And why I say that is I see a lot of similarities with this conversation right here. We have this section 248, which is a statewide process looking at statewide public good. And when we're talking about these interveners giving power to different interveners, we're changing the scope of where's the power in the process. Is it state level or is it local level? And what I want to say about that, and everybody who's talked before me is a lot more knowledgeable, and I thank all of them for doing all this work. But one thing I kind of want to point out is this seems like an innocuous change in some ways. It's very minor, but it seems to have ramifications beyond what the PUC was originally intending. And why I think this is a change in intent of this legislation is because if it wasn't a change in intent of the legislation, they would allow everybody to have this ability to, I forget what they call it, but anyways, fast intervening process. But obviously they didn't. The PUC decided just to include a few more entities into this process. And so in that way, it seems clear to me that there is a difference, right, between having this fast track intervening process and a normal, hey, I have a concern above and beyond what's going to be addressed by the state authorities. And so if it is a change away from the legislative intent, you know, that seems to be at odds. Again, I'm kind of a rookie at all this. I don't understand a lot, but it seems to me that the executive branch should be following what the legislature has written, and it doesn't seem like that is the case in this situation. So I really appreciate all of you digging into this and really understanding what the ripple effects are from this slight change. And I would appreciate you making sure that this 5.400 rule aligns with section 248. And that's all I had to say. Thank you.
Eddie? All right, thank you. Andrea Cohen, Manager of Government Affairs and Member Relations, Vermont Electric Cooperative.
Yes, thank you. As you know, we wrote you a letter and we outlined some issues. I won't, go through the whole thing. The letter that we wrote had some other partners on it from Stowe Electric Department, Renewable Energy Vermont and Velco all signed on. We had some common interests on this matter. I'm not going to go through everything that everybody did. I'll just put a point on a few things that meaningful to us. I'll start, I'm not a lawyer. I will refer you to in the packet, there was a legal memo from our counsel, a 17-page memo. Will go into those legal issues, but I will say we don't take it lightly coming in. We don't like to say to our regulators that we don't think you're being, that you're overextending your authority. But in this case, it's important enough that we actually are saying that, and we would appreciate the opportunity to get to a place where we can all agree that, what's going forward is reasonable and in compliance with the statute, as well as good policy and practical implications. 100% agree with the goals of making sure people are notified. I hope it's not misinterpreted that our pushback on this is because we don't want people to know about projects or have opportunity. It's really about what some of those implications are for how it's structured right now. So the notice requirement on its face is not, the problem. The problem is getting the waivers. If we have to get the okay from everybody we notice, and that list really expanded to who knows how many landowners, one example of 50, that's going to make it virtually impossible for us to ever do waivers. We don't use them a lot, but we might use them more. There's a lot of demands for infrastructure and rolling it out quick. We have IRA money, we have regulatory requirements, we're doing more distributed generation and more energy transformation. It's more complex, there's a lot going on, and we need every ability to move quickly and efficiently to get projects permitted. The waiver is something we have used, and I expect we did for Cambridge substation not too long ago, and I expect in the future we'd like more. So right now, if we go to the town and the RPC, they understand what we're trying to do, we have the conversation, we get the waiver, we move ahead. So I think the notice and the waiver, the fact that they're connected is where the problem is. It's not giving notice to people. Of course, we want people to know what's going on in their communities. And as Encore said, we're really happy to have that. And we do proactive work on that. And I know Velco does as well. So it's really just trying to get those waivers efficiently. The intervention by notice, I think, in our opinion, is really big. It's taking away our rights to push, to object to that. Like right now, if someone wants to intervene, wants to be a party, there's a process. We get to participate. We get to explain what we think about that and the PUC rules. How we read this draft rule essentially removes our ability to object to somebody intervening, and we really feel like that's important that we're able to do that again for moving projects along. Not that people shouldn't know about it, not that they shouldn't seek to intervene, but for them to have a specific interest and for us to be able to object to that if we need to, we think is important to preserve. So we do think it's a big deal, and it's important to dig in and make it so it works, so that people are noticed, they have the information, they have the ability to participate, but that these public good projects don't get unnecessarily delayed or more expensive because of that. Senator McDonald, looked like you had a question, but I'll wait. I don't know if that's true or not. So those are the fine points that I wanted to, emphasize, that it's not we're objecting to giving notice. We just really want to facilitate the waivers, and we want to be able to make sure that we can object to interventions and not lose our rights in that process through this rule. So I'll leave it there for right now. If there's questions, happy to answer.
Committee members? Senator Bray.
Has VEC participated in when a party wanted to become an intervener? Do you appear before the PUC to argue whether or not someone should be allowed in as an intervener, or to argue around the breadth or narrowness of the grounds upon which they are allowed to intervene, sort of the scope?
I might have to get back to you on that. I know we've participated. I think the PUC can share, process, but we are interested, like if someone doesn't have a particularized interest, I don't even think they'd get through the gate to start. But we do get to participate in that.
Representative Higley.
Thank you, Mr. Chair. If I could get an answer to that last concern from Mr. Cotter, I'd certainly appreciate it. And that is, does this new provision in the rule mean that the applicant doesn't have the right to object?
I think that what's preserved is the right to seek limits on an intervener's participation. And so the absolute right to say, do not let this person in, which we rarely see, it is, I think that's probably gone. But the right to say, don't let them participate on that issue, only let them participate on this issue, that's not gone. And if you look at the text of the rule, you'll see that it specifically says, it cross-references part of Rule 2.209C, I believe, which is the commission's authority to limit people's participation to certain issues. That any intervention that is done under 5.400 through the notice process is subject to those potential limitations. So the commission has not, in fact, just thrown the door open to us. I think it was Mr. Dowd and I were referring to the Wild West process. I just don't see that these changes allow that.
Thank you.
So we do see it as limiting our abilities and some of our rights to object. But that's the legal take. So let the lawyers look at that, see what they think, right? But we're concerned about that, obviously.
Other questions? Thank you.
Thank you.
Any general questions from the committee? Representative Higley.
Here, if I could, and I haven't been at this an awful long time, but again, we do receive or should receive information from the committees of jurisdiction signing off, whether it meets legislative intent or it's arbitrary or whatever. I understand that, since 2016, there may even be different players, but how does that, we've mentioned that our legislative council is in the room, but again, if it's more of a question of committee of jurisdiction issue, how can that be addressed in this instant?
I don't believe we've received letters. We have one of the chairs here, and we have the ranking member from the other committee and Representative Stephen Baumgart's. But you're right, there might be a time issue here in terms of knowledge about these issues. We certainly can ask both of them. Senator Bray is weighing in.
Yeah.
And certainly Representative Baumgart's had some comments also. We can circle back to that concern for next meeting, if that's useful to you.
I appreciate that.
Along with the information we'll get from Ledge Council. Senator Bray.
Yeah, so thanks, Representative Higley. It's not that unusual for me to want to hear the discussion in LCAR, and I'll literally sign off at the meeting. The best way for me to learn more about the questions I have is right when we get together formally, we take testimony here. So I haven't signed off on these because I had questions and wanted to hear today's discussion plus the memo that will be coming from the council.
Okay, thank you.
All right, so I'm going to move on here, but those folks that have participated, if they want to submit additional comments based on the conversation and the discussion we've had, we welcome those, but give them to us in timely fashion so we can certainly look at those. I think we'll move on to 23P20, Vermont Public Utility. Commission Rule 5.500, interconnection procedures, proposed electric generation resource and energy storage devices. And Jake Marin, we were told that these are separate, and I thought we can at least take this up, have that conversation, and hopefully move on. Floor is yours.
Good morning, and thank you for having me here. My name is Jake Marin. I'm an attorney for the Vermont Public Utility Commission. With me today is another staff member from the commission, Mary Jo Kraleski. We're here to discuss Rule 5.500, which governs the interconnection of electric generation facilities and energy storage facilities in the proposed rule. In 2006, the General Assembly directed the Commission to adopt by rule or order standards governing the interconnection of distributed generation facilities. In 2022, the General Assembly enacted 30 VSA Section 8011, which authorized the Commission to adopt similar standards for the interconnection of energy storage facilities, also usually called batteries. So this rulemaking is updating a rule that was adopted in 2006, and so it undertakes a fair amount of revision to the rule, and I'll give a brief overview of the changes we've made. We have revised the amount of an application fee. We've adopted standards for the interconnection of storage facilities. We've updated the procedures for filing an application, including simplifying those procedures for smaller facilities. We've also updated the technical standards and screening criteria used to determine what level of review are given to projects. And we've also established standards for so-called limited export projects, which means in the way that the rule operates now, a facility is evaluated based on its maximum theoretical output. However, with the advent of storage technology and other technologies such as smart inverters, facilities can actually have a greater amount of control about how much energy they export to the grid at any time, which gives operators more flexibility and the ability to operate those systems in a way that won't necessarily put the maximum amount of energy onto the system at specific times, which can allow you to interconnect more generation or storage to a particular part of the grid without causing the issues that you might have seen in the past. I'm just turning to the clean section, the clean draft of the rule I have. I guess I would just point out that I think, some of the more important innovations that we have in this rule is creating a tiered application system for generation and battery storage facilities. So we have processes and screening criteria for systems that are 15 kilowatts and less, which are very small systems that might be located on a homeowner's property. Those have a very short process and short application form that would be reviewed within 15 days. Larger projects can be reviewed within 31 days, and then even larger projects, utility scale projects, would go through a more traditional review process like we have currently. So this rule will be all encompassing and cover the gamut of the very smallest projects that are interconnected with the grid to the larger projects that are interconnected with our distribution grid. This rule does not cover the interconnection of systems that are jurisdictional to ISO New England. So if you had something that was measured in hundreds of megawatts or that was interconnecting with the transmission system or would have a significant effect on the transmission system, those projects would be reviewed by ISO New England and not Vermont Utilities. And also just to make clear, these are the standards that the utilities apply in reviewing these projects. The commission does not review the interconnection of projects. We do siting, that's a separate process. This is a utility process where the utilities engineers review proposals and ensure that they can be safely connected to the utilities distribution system without causing damage to the system or harm to the reliability or stability of the system. I think at this point, I'll just take any questions you have, and I thank you for your time today.
I didn't hear, maybe I missed it, the proposed modifications you made. You submitted some additional.
The proposed modifications?
Yeah.
I'll start with the storage. So the current rule we have only applies to energy generation facilities like a wind turbine or a solar array. It does not apply to batteries. Batteries don't produce their own energy. They have to be charged and then they can discharge energy. energy. So this rule has been expanded to cover the interconnection of storage, which is a very essential part of the energy transition. We need to be able to interconnect storage to the grid safely to facilitate more renewable energy and better operation of the grid in Vermont. The second, yes.
I think Representative Scroll was just talking about your request on November 28th of 2023 so that we can make sure the correct version of the rule.
Oh, I apologize. Yes. So just last week, I got an email from a fellow at the IEEE, which is an industry organization that adopts many of the codes and standards that are applicable to this, and notified me that we had a slight typo where we had misnamed one of their codes. So while we had identified the correct code, it's standard 519, we had not gotten the latest title to that correct. So we updated it. And that was the change that I sent around.
That was the only change.
Yeah, that was the only change.
All right, thank you.
Yeah.
Any questions? I have a motion. I'll read it. You can say.
Okay, do we have any other witnesses to hear on this?
No, we do not have any other witnesses.
Okay, thank
I'd like to approve Rule 23P20, Rule 5.500, interconnection procedures for proposed electric generation resources and energy storage devices with the proposed modifications submitted by the Public Utility Commission on November 28th, 2023.
Mr. Chair, I would make a motion that sounds virtually identical to that motion.
Thank you, Senator Bright. We have a motion. And any additional conversation, questions? All those in favor, please say aye. Aye. Those opposed? Thank you very much.
Thank you.
Notice you didn't have your paper in front of you.
Yeah, thank you. And I wasn't going to get it out in time either because I've been moving too many of these around.
Okay. The next item on the agenda was an update on 23P15, which is the fur bearer species rule. At our last meeting, the committee voted to approve the rule with a handful of objections, 3 to the trapping side of that, and 1 to the control of dogs hunting coyotes. My understanding is that the Fish and Wildlife Board is meeting, I think, right now to discuss recommendations made by the Fish and Wildlife Department responding to our objections. We've all seen that document and what those suggestions are. We don't know what the board has decided at this point. So we won't be having any discussion about that until we actually see a formal document from Fish and Wildlife, and we will take that up at the next meeting. Okay, any questions? Okay, thank you. Next meeting will be December 14th, and we have the rule we've been discussing here, 23P18. And then we have, I believe, another PUC rule, P23, P19. And again, like I said, we'll be taking up the fur bearer species rule. Any questions, further comments? This meeting is adjourned.